Hi everyone, today we will talk about Ashok Kumar Thakur versus Union of India case. In the Ashok Kumar Thakur versus Union of India case, the court went on to discuss the status of the reservation system in India. Our constitution laid down the basis for a classless and equal society. Action like reservation has been taken by the constitution and government to solve the problem of inequality in society. The diversity of India is unique from the other countries in the world. In this regard, there comes an article which is relevant for us, that is Article number 15, which talks about prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Clause 5 of this article says that nothing in this article or in subclause G of clause 1 of article shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward class of citizens or for the scheduled caste or scheduled tribe insofar as such special provisions relate to their admission to the educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of article 30. The judges who presided over this case were Dr. Arjit Pasayat and C.K. Thakkar. As a background, we should know certain facts regarding this case. In 2006, the government reserved 27% of the seats for students from the OBC segment in institutes of higher learning in India. The Indian Parliament passed a bill to bring out an amendment in the constitution in this regard. This was challenged by Ashok Kumar Thakur on grounds that this was against the basic structure of the constitution and it abridged the principle of equality under the Article 14 read with Article 15 of the Constitution. The said amendment, along with the Central Educational Institutions Reservation in Admission Act 2006, was further sought to be challenged on the grounds that the Union of India had failed in performing its constitutional and legal duties towards the citizenry and that this would have wide ramifications and ultimately result in dividing the country on a caste basis. What were the issues in this case? The issues included whether the 93rd Amendment of the Constitution is against the basic structure of the Constitution, whether Act 5 of 2007 is constitutionally valid in view of the definition of backward class, and whether the identification of such backward class based on caste is constitutionally valid. Act 5 of 2007 is nothing but Reservation in Admission Act of 2006 itself used to be known as Act 5 of 2007. So, the issue number 2 was whether Act 5 of 2007 is constitutionally valid in view of the definition of backward class and whether the identification of such backward class based on caste is constitutionally valid. Next issue was whether the creamy layer is to be excluded from the socially economically backward classes. So these were major issues with regard to this case. What were the contentions of the petitioner? It was argued by the petitioner that the provisions of the Act are facially violative of Article 14 and it could be justified only on the basis of compelling state necessity. A greater degree of compulsion is necessary to establish a compelling state necessity than what is ordinarily required to be shown in the case of economic legislation. The validity of the Constitution was further seriously challenged by arguing that the amendment is destructive in the basic structure of the Constitution. The petitioner contended that the caste cannot be the sole criteria for determining the socially and educationally backward classes under Article 15.4 and 15.5 of the Constitution, and the test for Article 15.5 has to be operation cum income, where caste may or may not be one of the many considerations having a nebulous weightage, and alternatively, without conceding if caste at all is taken as one of the many considerations, then it can be those castes which satisfy the test of similarity with scheduled caste and scheduled tribe. The petitioner contended that the admission to educational institutions should be based purely on merit and to allow a state to prefer a student with lesser merit over a student who would have otherwise got admission is ex facie discriminatory. So these were the contentions of the petitioner. What were the arguments that were given by respondents? The respondents contended that the contentions of the petitioner challenging the 93rd Amendment Act of Constitution and Act 5 of 2007 are without any merit and are liable to be dismissed. It was further contended that on a harmonious reading of the preamble, part 3rd and part 4th, it is manifested that there is a constitutional promise to the weaker sections, that is, socially and economically backward classes, and this solemn duty has to be fulfilled. It further strongly contended that the validity of the constitutional amendment and the validity of the plenary legislation have to be decided purely on the basis of constitutional law, and the contention that the amendment was a vote-catching mechanism is inappropriate. What was the judgment in Ashok Kumar case? The court said that the 93rd Constitutional Amendment Act of 2005 is to be examined in the position as laid down in the Keswanand Bharti case. The judgment in the Keswanand Bharti case clearly indicates what is the basic structure of the Constitution. The court also took note of the fact that the majority in Keswanand Bharti did not hold that the facets of Article 14 would form a part of the basic structure. The court further went on to say that when a constitutional provision is interpreted, the cardinal rule is to look at the preamble to the Constitution as the guiding star and the directive principle of state policy as the book of interpretation. Therefore, the court held that the 93rd Amendment to the Constitution does not violate the basic structure of the Constitution so far as it relates to state-maintained institutions and aided educational institutions. The court held that the determination of the socially and economically backward classes is done not solely based on caste, and hence the identification of the socially and economically backward classes is not violative of Article 15, Clause 1 of the Constitution. Therefore, Act 5 of 2007 is not invalid for this reason. The court held that the creamy layer is to be excluded from the socially and economically backward classes. The court also held that the creamy layer is to be excluded from the socially and economically backward classes, that is SEBCs. The court also held that for the purpose of reservation, the principle of creamy layer are not applicable to the scheduled caste and scheduled tribe. The court further held that it is not futile to contend whether Parliament was not aware of the statistical detail of the population of this country, and therefore that 27% reservation provided in the Act is not illegal. If we analyze Ashok Kumar Thakur case, to answer the question as to whether it violated the basic structure, the Chief Justice referred back to Keswanand Bharti and distinguished between the concept of abstract equality and specific equality. It is to be understood an amendment that seeks to damage or destroy the concept itself is void. The court further stated that the larger principles of equality, as stated in Article 14, 15, and 16, may be understood as an element of the basic structure of the Constitution and may not be subject to amendment. Although these provisions intend to configure these rights in a particular way, may be changed within the constraints of broader principle. The variability of changing conditions may necessitate the modification in the structure and design of these rights, but the transient characters of formal arrangement must reflect the larger purpose and principles that are the continuous and unalterable thread of the constitutional identity. It can be understood that what is important is the level of abstraction at which an amendment addresses and modifies equality. From an analysis of Nagraj and other cases, it can be understood that only an amendment that brings about a state of affairs that could not be reasonably covered by any conception of equality would fall foul of the basic structure. In this case, Article 15, Clause 5 was at best a moderate abridgment or alteration of the principle of equality. The basic structure challenge failed. So this sums up our discussion on Ashok Kumar Thakur versus Union of India case of 2008. If you like watching such landmark cases, do not forget to like, share, subscribe, and comment. Thank you so much for watching, and stay tuned for more such videos. Thank you.